All right. Well, welcome everyone to our webinar about due process, of course, specifically due process as it relates to special education. My name is Amy Beck. I'm an associate attorney, a special education attorney with Altman Law. And of course, we have our founding attorney, the name on the door, Mr. Keith Altman here. Keith, if you want to give a little background about what you do, about our firm, and yeah, you can take it away.
Sure, everybody. So at Altman Law, we very much specialize on working with students. We have kind of a unique structure where we can assist on the special education side students all the way from initial eligibility assessments all the way through due process and beyond. And I don't know of any other firm that can do that. We have a fantastic team of educational legal professionals that work together to try to get our clients the best possible outcome. On our litigation side, we've done some very large, important litigations. We've had a few cases at the U.S. Supreme Court, and our goal is to really work with students. We're very student focused. Due process is clearly a very key area. I mean, it is the ultimate endpoint of a dispute between a parent and the school. It's in a very important area, and we talked about it and thought it'd be a really good idea for us to talk about due process. Just from the firm's perspective, we do a large amount of due process hearings. These are not for the faint-hearted. For anybody in the audience who is an attorney, can be very complex situations, but after you get a handle on it, you manage it, they just kind of flow. So, Amy, I'll turn it back to you. Thank you, everybody, for coming today. And I wish I could see you, but unfortunately, I'm essentially blind. So that's one of the specific challenges that I have, having lost my vision a few years ago. Go ahead, Amy.
All right. So if you saw that in the chat, Crystal did just drop, she's from our firm and she also dropped a message. If you'd like to ask any questions, please feel free to drop them in the Q&A. If you have questions that relate to the topic we're currently on, we can definitely answer those as we're going. But if you have any questions you'd like for us to answer at the end, please feel free to drop them in the chat. And if I miss your questions, Crystal is also going to be monitoring that chat, so she'll be able to let me know if I miss anything. All right, well, let's get started. And what is due process? What happens? And you kind of gave us a brief insight, Keith, the ultimate dispute between the parent and the school, but can you give us a little more details about what kind of disputes and when is a due process absolutely necessary?
Well, due process, with the special education process, once the parents believe that their child needs special education services, they have the ability to request those services. The guiding statute with respect to special education is IDEA, and that sets forth all the parameters. Schools have an affirmative obligation to be looking for children that may be at risk of having their education impacted by specific disabilities. But sometimes that process doesn't go through so well. So, I'm not going to spend a lot of time talking about the due process, the special education process, but essentially, once a child is identified as potentially needing services, they have to be evaluated. If they're found to be eligible, then a determination will be made whether they should be getting a 504 plan or an IEP, which is an individualized education plan. And there sometimes can be disputes between the parents and the school as to exactly what the student needs, or if the student needs specific placements, or if they need certain educational resources. And while the parents can have a negotiated discussion with the school, sometimes you come to an impasse. Parents just can't get what they want. In that particular case, the next step of the process is to file a due process complaint. Um, every state has its own slightly different version of how a due process works, but the overriding principles still come from IDEA. Due process matters are typically held in administrative proceedings. They often can be done remotely by Zoom. Sometimes they're done in person. I've done both. I've gone both ways. But effectively, the parents and their representative and the school and their representative will come in, and there'll be an administrative law judge who will oversee and hear the process. So that's just kind of the general overview of due process.
Yeah, maybe you can give us kind of a brief example situation that you've been in that a parent has had to file due process.
Sure. We're actually in the middle of a due process hearing as we speak. We had yesterday, we'll finish it up tomorrow, where there was a question of number one, whether the student would graduate in 2025 or beyond, whether he was capable of graduating. And if he was not capable of graduation, he does have some complex behavioral needs, and he is currently in a residential private school. Where will he go? The school that he's at, he ages out of on his 18th birthday, which is this month, and the school will need to find a new appropriate location for him. So that's a typical kind of dispute. Another kind of dispute is where perhaps there's an IEP developed and the student is supposed to receive certain services, and for some reason the school can't provide them. The student would be entitled to compensatory educational services to make up for that, but maybe the school doesn't provide those services. And once again, how those services get delivered is in dispute. That also can be a due process hearing. So those are just two basic examples.
Great. And then the next one really would be, how do we get to due process? Why do we get to due process? I know you talked about, it is really the ultimate dispute, right? But there are situations that it may not require due process. So when do we need due process, and why, and what does a parent need to do to prepare for that? And what do we do to prepare for due process?
But due process is a last resort. Our philosophy is education, not litigation. And due process is litigation. It may not be as formal or as overreaching or overarching as a traditional lawsuit, but it's still litigation. It still has many of the same rules. It still has a lot of the complexities. So, in our perspective, parents should do everything they can reasonably do to protect themselves and to prepare for the eventuality of due process. Somebody much wiser than me said, if you prepare for a trial, you'll get a settlement. And if you prepare for a settlement, you get a trial. Every time we get involved, we prepare for a trial, which puts us in the best position to possibly negotiate a settlement. And that's how many matters that ultimately could go to due process, they don't actually have a due process hearing. A lot of times they're settled before the due process complaint even gets filed. And even then, there's mediation that can take place during the process. And a lot of times matters can be resolved in a kind of a structured mediation. But, in the end, it's important that the parents have the right. There's something I refer to all the time as the golden rule. It's them with the gold makes the rules. And a lot of times the school have the gold, or at least they believe they do, and the parents are behind the eight ball. And due process is meant to level the playing field a little bit, to give the parents a chance. And a lot of times it's not supposed to be, but a lot of times schools make decisions based on costs. Now, I agree that two solutions that are equally adequate, the school can select the cheaper option. But if there is no alternative and there's only one choice, then the school's got to implement that regardless of the cost. And some of these costs are considerable. For example, we're dealing with, some of these external private placements can be three, four, $500,000 per year. These are considerable expenses, and you can be sure schools don't want to pay those monies. And I understand, but under IDEA, they have to.
And yeah, you touched on mediation. Can you talk a little bit more about when do we get to mediation? What happens in mediation?
Well, you can always mediate unofficially at any time, but once a due process complaint is filed, then there will be an opportunity for mediation or some variation on mediation. We did a due process in Virginia. It's called a resolution meeting. Some other places call it literally a mediation. They provide a mediator to help resolve the matter. That would be different than the administrative law judge, which I'm going to refer to as ALJ, but that's what ALJ means. And mediation is an important component. I'm a big believer that there is no strategic advantage to keeping everything a secret. To put it a little obnoxiously, frankly, I like to show people my 357. I like to open it up, show them that there's 5 out of 6 bullets. I like to close it up, spin it around, and ask them if they want to play. I mean, to me, there is no strategy to have secrets. It is to lay things out, to have a rational discussion. And in my position, anytime that you have an opportunity to hear from the other side and understand the other side's perspective, it is not a waste of time. And you can use, although you can't discuss the settlement discussions itself, the mediation can still inform you of where the other side's perspective is, and excuse me, put you in a much better position to try to prepare for your due process.
And you said they can go to mediation at any time. Is that something that they can require the school to attend mediation? Is that something that they can set up on their own? Do they have to go through the Department of Education? How does that work?
Well, there's different kinds of mediation, but with respect to due process, um, mediation tends to be a voluntary type situation. Either one or the other party or both can refuse to do mediation. I suppose that there are some states that can require mediation as part of the process before due process, but in most of the instances I've seen, it's a voluntary proceeding. It will sometimes stay. There are strict time limits with respect to due process. Mediation will tend to slow things down a little bit because that will kind of stop the clock from ticking. And it generally happens pretty quickly. I mean, a due process from the time you file the complaint till the time you have the hearing is supposed to take about 45 days. So these things move fast. You throw mediation in there and it can slow it down just a little bit.
So is there any negative impact to skipping mediation?
Well, I just think that sometimes, you know, I think sometimes disputes are more related to lack of communication than actual meaningful differences. And so I think sometimes in a mediation, um, if you have a good skilled mediator, a lot of times the mediator can draw out from the parties that they're both saying the same thing, just using different words. So I think not having, to me, I don't believe there's an advantage to not having a mediation. I think it doesn't add much time, and I think there's a good chance to learn more about the other side's perspective.
And then we did have a question come in asking if they should have a lawyer or an advocate present with them at a mediation.
Sometimes I'm a terrible salesman, but this is one of those instances where I think you do need somebody who is skilled and knowledgeable, because assuredly the other side they'll either have an attorney, they'll have skilled advocates. And I think the problem generally with parents, it's not that they don't know the data. And what I mean by the data, in dealing with special education matters, I think the parents know what the essential information is. I think where there's lacking is how do you apply that information to achieve a result. So I think it is important in a mediation um, to have somebody there who's skilled to help you through that. And one of the things happens is, frankly, in any good mediation, everybody walks away a little bit unhappy. If that's not the case, then it's unlikely that the mediation went well. You're not going to win at a mediation like you might have won at uh, through the resolution of a due process hearing. And to get there, I really think you need to have somebody skilled with you. It doesn't necessarily have to be an attorney, but it has to be somebody who really understands the landscape.
Right. And then what happens at the end of mediation? If either way, either if they come to a resolution or if they don't, what's the next step there?
Well, if there's a resolution, and a lot of times what will happen is the mediator will keep the parties in a separate room, and there'll be a demand, then there'll be an offer, and then maybe there'll be some movement. If there is a finally resolution, then the mediator will get the essential terms of the resolution. School will do this, school will do that, parents will do this, parents will do that, and that will form the basis of a written agreement. That will form the results of the mediation, which would have the resolution. If there is not a negotiated settlement, then the next step is going to be to go to the due process hearing, which will come up, soon after, unless the parties agree to extend the time, which they can and often do.
So if there's an agreement out of mediation, due process is over?
Yes, yes, that would be the end of due process, but that's up to that particular point in time. But that doesn't mean that if the something else happens, or the school, there's a change and the school doesn't reflect it, that you might not be back in the due process at a later time. And the other thing that's important about what comes out of the due process, it is a contract. It is a very specific thing that you can litigate based upon. I would hope that if you resolve a matter, that both sides would honor their commitments, but it doesn't always happen that way.
Right. And then so after mediation, if it's unsuccessful, we move on to the hearing. Does anything happen between mediation and the hearing? Are both parties just preparing for hearing?
Well, I think they're preparing for hearing, but one of the key things that will happen before the hearing, and probably 30 days in advance, there'll be a meeting with the ALJ to discuss pre-hearing matters. One of the most important things that will happen in that pre-hearing meeting will be an establishment of what the issues are that are before the ALJ. This is very, very important. You don't want to have too many issues, because then it just becomes impossible to manage. You want to really focus on what are the essential issues that will achieve the results that you want. And often it's far fewer than what you might think. And it's not a time, you do have to make a judgment call as to what are the important essential issues. You can't have a due process hearing with 25 different claims. That just doesn't work. You really want to try the 2 or 3 that in essence will drive the point home. And sometimes resolving those 2 or 3 issues can lead to the development of the other issues as well. So that's one of the very key things. The conduct of the hearing will be described, when witness lists need to be submitted, when exhibit lists needs to be submitted, scheduling the due process hearing. Sometimes, they can take one day, but that's unusual. Typical time for due process is about 3 days. So all of that's a very, very important meeting that will take place. Sometimes you'll see motions being filed during the time between the pre-hearing meeting and the actual due process hearing itself. That's a little more unusual, but it does happen. We had a case where the school filed a motion for summary judgment in between. That doesn't often happen, but it can. And in that particular case, that ups the ante in terms of complexity of the matter.
So you mentioned in the beginning the difference between litigation and a due process hearing. Maybe we can go into a little bit more detail about what makes a due process hearing so different from litigation. Because I'm looking at the slide right now, and you mentioned motions and witnesses and all that, and I think there's just a lot of similarities with litigation. But you and I both know that due process does work a bit differently. Maybe you can speak to the differences you've noticed as someone who's been in both scenarios.
Well, the ALJ has a lot to do with it, which is the same thing in litigation, but ALJs tend to be less experienced with respect to litigation matters than judges, and that'll make a big difference. Just like a litigation, the judge has enormous control over the proceedings, so does the ALJ. While there's still formality in a due process hearing, it's less formal than a court. The rules of evidence are more relaxed. When you're not in front of a jury, the ALJ has more discretion to let more evidence in, and be able to filter out the evidence than a jury might be able to do. And some ALJs will have a very expansive belief of what should be allowed in terms of evidence. When you're in front of a jury, it's much more constrained. The rules matter more. Questioning, for example, is a little more flexible in terms of the kind of questions that you can ask. The flow of the hearing is somewhat a little bit more flexible. But there's still witnesses, there's still evidence, there's still having to admit evidence, and all the procedural issues that go along with that. What I can tell you for sure is a due process hearing is not something that a parent should try to do on their own. You need help. It doesn't necessarily have to be an attorney, but if it's somebody who's not an attorney, they have to be really skilled at what they do and really understand the process. And there are, many um, there are many, many special education advocates who have been involved in a lot of due process hearings and know the process very, very well.
Can you walk us through just what does day one of a hearing look like? What happens?
Well, there's a few things before that. Typically, a week before the hearing, the parties need to exchange witness lists and the parties need to exchange exhibit lists. And unlike litigation, which typically has a discovery rule, and you can request certain documents, that doesn't really apply in a due process hearing. Both sides just put in, proposes whatever exhibits that they want. On the first day of the hearing, um, you will spend a little bit of time up front, just laying out some of the ground rules, which may not have been covered in the pre-hearing, go through some procedural questions, and then, the claimant, and the burden of proof is on the claimant, the parent, and generally they will begin with their case. Now, there are many schools of thought in terms of what witnesses you call, the order that you call them in, how you do those kind of things. I am a believer that I like to call the district, the key district people first in my case. Those are the first people I bring up. Then after the district witnesses, I move on to the professionals that have worked with the student. So any psychiatrists, psychologists, social workers, any of those kind of people. And then I like to move to, if there's a placement issue, I like to end that with somebody to come in and talk about the placement that we're looking for. And then I like to finish up with the parents. And so that's my particular structure. Other people have different thoughts. Reasonable minds can disagree. And I think it's very important, though, to begin with the district employees, to kind of lay the foundation out of what's going on at the school at that time.
And I missed a question from earlier when we were talking about mediations, but we did go to a question asking what's the difference between mediation and arbitration?
Huge difference. Arbitration, once you agree to it, that arbitrator will resolve the matter, period. Mediation is voluntary. The mediator can't force anybody to do anything. If you go to arbitration, the arbitrator is going to make a decision. And with respect to a due process hearing, I don't see any advantage to moving to arbitration. You might as well just go to an ALJ hearing officer. With arbitration, the rules are much more restrictive than what might be permitted in a normal due process hearing. And I don't see any advantage to go to arbitration, nor do I believe arbitration. A lot of times, arbitration is not an truly optional step. And in an arbitration, there will be an arbitrator, and they will make the decision, and there's no appeal of an arbitration either, unlike a due process case. So I don't think you have arbitration because generally no parent would ever voluntarily agree to engage in arbitration. We see arbitration more often in consumer contracts where you don't really even have a choice. It's not like you can say, hey, I don't want arbitration. It's forced on you. You get a cell phone, they force an arbitration. You go to a bank, they force arbitration on you. More and more, you don't have the ability to truly resolve a dispute. And I suppose there is some benefit to that, but it's certainly much more to the defendant corporation's perspective. So I wouldn't worry too much about arbitration in a due process context.
And you mentioned earlier with mediation, it resolves what has happened, but going forward, there may be other issues. So we did get a question asking, once the mediation is over, what if there are additional civil rights violations or other violations? How do we pursue that?
You can Due process is a step in the process. Going through due process is really about trying to force the school, the educational institution, to do certain things for your child. It does not and cannot award damages. It cannot resolve negligence issues. So that is something that you would have to explore in court. Now, for example, if you go to a due process hearing because a child is not being provided their accommodations. Um, you might wind up in both places, through due process to force the school to provide the accommodations, and through regular litigation to compensate for damages caused by not providing those accommodations. Like we have a case we're working on where a child was not supposed to have his feet off the ground because he had had some seizure issues. And a teacher allowed him to go on a swing. While he was on the swing, he passed out, flew off the swing, hit his head, got a concussion. So there's really two issues there. He didn't get his accommodations. That could be due process. And then he was injured. That could be a regular lawsuit.
And then we had another question that just came in. I think she says, or he says, I have minor disagreements with the offer of FAPE, a cut down in service minutes for OT, and accommodations cut down to half. I will not sign the IEP. At this point, I am expecting the school to take me to due process. What can I expect and how can I prepare? But before you answer, maybe we can explain what FAPE is, what it stands for, what it means.
FAPE means free, appropriate public education. Every child, whether neurodivergent or, having no difficulties, is entitled to a free, appropriate public education. Exactly what FAPE is a little nebulous at times, but that is the foundation and the basic principle. And you will often see due process clause, claims that the child was not provided FAPE. And that's something that has to be assessed. And it's just not that FAPE can be different for different children. We have a due process case that we're dealing with where the student is 16, has the mental capacity of an 18-month-old. And so FAPE for that student is going to be FAPE for a student who's all honors, but both are entitled to FAPE in context. Anyway, with respect to what can you do, obviously, um, if the school decides to move to due process, you're going to have to defend that. And it's just not I wish it were more simplified. And I'm sure that ALJs will provide more, um, ALJs will provide more latitude to a parent who's unrepresented, but you are at a tremendous, tremendous disadvantage at that point. You're going to have to see, and you can reverse the issue, frankly. Instead of waiting for the school to take you to due process, you can take the school to due process, potentially. So you're just going to have to see in that context.
And that actually does segue into another question that we got much earlier, but the question was, do you recommend parents file a due process complaint on their own?
I don't think so. I just think there's too much there's too much at stake, too much involved, and like I said, while I think an ALJ will give more latitude to parents, um, it's just you're up against almost assuredly an attorney from the school district, several experts in the field of special education. I'm not a I'm not a believer in attorneys having a mandatory place in a lot of situations, but I just think this is one of them.
And that leads into the other question that was also asked, is it harder to win a due process case without an attorney?
I think for sure it is. I just think, you're probably not going to have the ability to recognize when a school is taking advantage of the situation. For example, objecting to questions being posed to witnesses without having significant skills on evidence. I just think you're at a huge disadvantage. And I know you could say that I'm biased because I'm the attorney that does that, but I did go to law school for several years, and I have been doing this a long time, and experience matters.
Right. And in my experience, I've seen, the parent does get called as a witness typically. And how I've never seen it where a parent's represented themselves in due process. How would that work? If you know, of course.
Well, it's an interesting situation, and to be honest, I haven't been there for one of those either. So I can't really say. It does open up some complexities. How does a parent who is representing themselves, how did they give testimony? And maybe they just give it in a narrative format and then they can be cross-examined. Uh, but being cross-examined, it's hard enough being cross-examined when you don't have to focus on anything. But when you also have to be the attorney and be able to object to questions under cross-examination, that I just don't even know how you do it. For example, I've been deposed several times in several contexts, and I would never consider being deposed without somebody there representing me at the time.
Right. And there was another question that came in. It's a little bit longer. If a school has reduced a 4-year-old pre-K student from full day to half day due to behaviors, when questioned at a CSC transition meeting if this was a change in placement, the school indicated this was not a special education change of placement because they made the decision for the child as a general education student. Is this a situation that would allow due process to occur, even though the district is claiming they are doing it under general ed and not special ed?
Well, the key factor there, does the child have an IEP or a 504 plan? If the child has an IEP or a 504 plan, I believe that would constitute a change of placement,
They
and they
said
would have
yes,
to,
they do have an IEP or 504.
well, then I think it's a change. It doesn't matter. Somebody with an IEP, for example, has dyslexia, can still be in a general education classroom. That doesn't change the fact that they still have an IEP or a 504. So it's my belief that if they have an IEP or a 504, they're making a change to that. They can't do that in the IEP without, a resolution. They can't just simply say they're doing it just because he's in gen ed. So no, I think you'd still be protected.
And I think we've talked more about, when a parent has an issue with the school, when they file for due process. What types of situations have you seen where a school files for due process?
Well, we had a situation come up where the parents wanted an IE, an independent educational evaluation. And they can be, for a full one, it can cost $5,000 for such a situation. And the school did not want to pay the cost of an IEE, and this was becoming an issue with respect to the child's uh, IEP. And the school brought the due process because they wanted an order that said they didn't have to do the IEE unless the parents wanted to pay for it. So that's a context, or where the parent won't sign a revision to an IEP. At some point the school has to do something, and they could bring a due process at that point.
Gotcha. All right. Now circling back to what we're talking about, the day-to-day of what the hearing looks like. Maybe we can talk a little bit more about, what goes on with witnesses, because we did receive a question. Do witnesses see or hear each other answer questions in the hearing?
Well, typically, many due process, if it's done live, then of course, yes. But many due process hearings are done remotely by Zoom. Uh, when it comes to us acting in due processes, we do these all over the country. I am not licensed all over the country, and we have to seek what's called pro hac vice status, which basically is asking the court for permission to represent the parents in this particular case. And it's routinely granted, but it's a procedural hurdle that just has to be gone through. And trying to find a skilled education lawyer in some states or locales is very, very difficult, which is why we do these all over the country. But in terms of witnesses, let's just say it's done by Zoom. And I brought that up because many of our due process hearings, they are by Zoom because we are remote. And that's an option that the parents can generally select whether to do it by Zoom or not. Um, Everybody sees everybody on Zoom. And in fact, all of the essential key personnel, including a witness, will need to be able to be seen on camera. And yes, witnesses will be questioned. Typically, they'll be questioned first by the party calling them. A due process hearing is broken up into two parts. First, the parents have the burden of establishing the issues. And it has to be done by a preponderance of the evidence. You hear like a criminal proceeding beyond a reasonable doubt. This is a much, much lower standard. It's 51%, just more likely than not. During the parent's case, the parent will call various witnesses. Some may be members of the family. It could be the school district. When the parents call the school district will be known as what's called as an adverse witness. which really just affects the way that you can question those individuals. Um, when a witness is called, if it's called by the parent will ask the witness questions first, and then the other side will be able to cross-examine the witness, and then the parents may be able to do a redirect. And when I say the parents, I just mean the parent side. It's generally going to be by an attorney, but the parents can then question the witness with redirect, and this may go back and forth a few times. And even the ALJ can ask a question of the witness if they think of one that they want to ask. So that's pretty much how things will go with witnesses. After the parents have put up all of their witnesses, sometimes there's what's called a motion for directed verdict made by the defendants, which is basically saying, Your Honor, they put on their case, they haven't met their burden, you can't find in their favor, and we shouldn't have to go through putting on our case. And those are generally not granted. If anything, they're held in reserve, and the ALJ can rule on it after the case. And sometimes they do that because, if she decides without dealing with the ALJ in favor of the school, then she doesn't have to worry about the motion for directed verdict. It's really only if she would decide for the family that she might consider it, but I think it's generally a moot point. But after the family has put on their witnesses, the school will then put on their witnesses, and then there'll be closings, and then the ALJ will make a decision.
And in regards to witnesses, there was also a question asking if the student may be required to testify or if that's up to the parent.
It really depends. I mean, the case that I'm going to be doing next week, the student is nonverbal, okay, and she has the mental capacity of an 18-month-old. How can you expect to get effective testimony out of that? A lot of times the students will not testify. It's hard to get meaningful information, especially if they're significantly disabled or they're autistic. These pose challenges. And so we often don't see the student. In fact, none of the due process hearings I have been in. Well, no, that's not true. One of them, the student had medical issues. She was not in any way developmentally disabled. She just had medical issues and couldn't get the services that she really needed without kind of being home health, working from home, which is really much less desired than being in school.
All right. And we did have another question come in. With respect to mandated reporting, a teacher, a para, or anyone working with children can file a report. With regard to due process, can a principal, counselor, or teacher advocate for a SPED student in a due process conference or file a complaint on behalf of a student or parent?
I'm not sure if they can file a due process complaint. I haven't seen that happen. I mean, that generally has to be done by the student. But certainly, if the complaint is filed, teachers can advocate for a student as a witness, and we see that happen. So that's a definite possibility. But I don't believe that they can actually file the due process complaint on behalf of the child.
Right. Okay, so and then once we've gone through all the hearing days, regardless of if it's 3, 5, however it may be, how does the hearing come to a close?
Well, once the school has rested. Well, and I guess that could depend on whether the school brought the due process complaint in the first place. Because once again, the burden is the same on the school as it is on the student. If the student brings the process, it could just be reversed. After both sides have gone, they've called all their witnesses. It's a little unclear. Sometimes you could see an attempt to call what's called a rebuttal witness, which is not specifically excluded or allowed. I think it's up to the discretion of the ALJ. Then there'll be closing statements, and the ALJ, and typically this is negotiated beforehand, the ALJ will have set a date by which they will provide their decision. And it has to be in writing. It has to explain the basis and of their decision so that people can understand exactly why the decision was made the way it was made. Now, once the hearing is complete, if the parents prevail, then they're able to seek attorney's fees. Now, the ALJ cannot award attorney's fees to the parents. Um, and the only legal way you can get them, sorry, is by bringing a suit in federal court. But I believe the time that you spend bringing that case itself is also recoverable. And many times the attorney's fees issue is resolved in post-hearing discussion, and there's rarely a actual hearing for attorney's fees, but it is certainly possible. Um, Now, there are ways to appeal an adverse decision from an ALJ. Um, Often that can go to, depending on the state, it may go to the local state court, the basic state court. It's possible that it will go to an appeals court. Um, and generally, you are able to bring litigation despite an adverse due process decision. That doesn't necessarily preclude you from bringing actual litigation based upon the issue. Um, you might also see before the ALJ renders their decision, you might see negotiation and still resolve the matter, even though the hearing has actually taken place. That also often happens.
So you can keep talking to the school even after you've gone to hearing.
Of course. And if the school believes that it's going to get an adverse finding, they may find it in their favor to try to resolve it.
And what
And
type of
people,
resolutions may come out of that? Are they binding? Are they written out agreements?
oh yeah, absolutely. I mean, if the parties come to a resolution at any time, and even after the ALJ makes a decision, my cousin once told me about a case that IBM had lost, and IBM told the winner of the case, "We'll settle with you at this point if you pay our attorney's fees." I mean, so even when there's a loss, that doesn't mean that you can't negotiate a settlement anyway, because the school has to evaluate whether there's going to be any appeals, whether there could be any parallel litigation. And so sometimes things will happen. But, one of the hard things is there are certain kinds of things that you're doing that have a sliding scale, shall we say. So let's say, for example, you're trying to negotiate how many hours of services your child would receive. And let's say you want 20 hours and the school wants to give you 10 hours. Well, that's the kind of thing that maybe you can maybe agree upon, something in the middle. But there are other things that are just purely binary, and it's either I'm right or you're right. For example, if you believe that your child needs a private residential placement, okay, there's no real middle ground on that. It's either you get it or you don't. And those are the kinds of things that are much harder to try to negotiate at any point in the process. And sometimes you need somebody to just make a call. As I said, reasonable minds can disagree.
Gotcha. I don't see any further. I think we've pretty much wrapped up, the whole procedure for due process. Are there any other important key points you think we need to talk about in regards to due process?
Sure. Well, let's talk a little bit about the preparation. Documentation is very, very important. But you don't want to throw anything and everything. Okay. You want to be judicious. But if you're working with a firm like ours, you know, get the whole collection of material together, and then the firm can work with you as to what is the essential information. Unlike a litigation where you have certain obligations to present certain documents, you don't have that obligation in a due process hearing. You can provide as exhibits just the documents that help you, and not documents that hurt you. And that's just the way the world works, and it works the same way the other side. They can do the same thing, and a lot of times you'll see just things that you would expect to be there that are just not there, and you don't have any ability to get them. But preparing the documents is really, really important. Developing a strategy for how you're going to call your witnesses. I say to my people, before you call a witness, Ask yourself, what do I expect that witness is going to give me? See, in any argument, there are what I call failure points. If you push on the failure points of the other side's argument, you make them fail. And sometimes it's just a few things that you need to deal with. For example, there's a due process hearing that I'm going to finish up tomorrow, where really the essential element was the projected whether the student is going to graduate at the end of this school year. If the student graduates at the end of this school year, then the school has no further obligations to educate him. And if he doesn't, then if he doesn't, then they're going to have to figure out he's in a private residential placement now. They're going to have to figure out what private residential placement is he going to go to, because that's part of his IEP and not going to change. So the failure point is clearly on whether he graduates or not. And if you squeeze on that, and we spent a lot of effort showing that he could not graduate this year. And once that's resolved, everything else kind of falls into place. So that's the key failure point. So you want to look at your witnesses, and you want to you want to look at the failure points, and how do the witnesses either help you squeeze on the other side's failure point or help enhance your arguments. And if they can't do either one of those two things, don't call the witness. Samuel Clemens once said, if I had more time, I would have written a shorter letter. And I really believe that. And sometimes less is more. And you know, you have to ask yourself a question before you cross-examine a witness. The other side's witness. Am I going to gain anything out of this? Did they really say anything that'll hurt me? Or if they did say a lot that will hurt me, and I don't really have a way to really refute what they're saying, do I want to give them a chance to reinforce their opinions and to just double down? I don't think so. And it takes, and that's one of the things that takes a lot of skill, is to figure out the order of evidence, how you want to put your evidence in so that you can be most effective. And it takes a lot of skills and experience. And that's the kind of thing that parents are just not likely to be able to do without significant training.
Yeah. And you talked about, all the relevant documentation, exhibits, things like that. Can you maybe describe what type of documentation is the most important, and what documents does a parent need to provide to the firm or the counsel that's representing them?
Look, the parent should provide all the documents to those that are helping them, and let those that are helping them decide what's important and what's not. But some of the really key documents are um, the IEPs showing the IEPs over time, report cards, showing progress. Um, if you have a child that's dealing with behavioral issues, um, evidence of those behavioral complaints made by the school. One of the things that's very important with respect to those having an IEP or 504, if they get into behavioral issues, something they have to, and they're going to want to suspend the student or change the placement for more than 10 days, cumulative through the school year, they have to conduct what's called an MDR, a manifestation determination review. And this is a meeting of the IEP team. And the only question is, did the child's disabilities or issues cause or contribute to the offensive behavior? And if so, except in very limited circumstances like extreme violence, if a special education student comes to school with a gun, okay, and even if it was their impulsivity that caused them to do that, they're still going to be severely sanctioned over that. But if it's not something like that, then the school has to sanction them in a different way, that is more educational and less punitive. Now, I see this disturbing trend these days that schools would be happy to throw a student in the garbage. In Texas, particularly, they have something called DAEP, which is their alternate schools. And I actually had a situation, they wanted to send a 5-year-old kindergartner to an alternate school. It's just ludicrous. But we do see those kind of circumstances, and so the whole MDR issue becomes extremely important in that context.
Yeah. And I think that brings up a good point about, schools and how they treat these students. We had a comment/question saying, I'm worried that the school district will treat my child poorly or become biased against my child if I file for due process, especially if the child has returned to the school district after the hearing. So the question is, what do you suggest I do in order to ensure that my child remains protected by the school district after the hearing?
Well, you have no way to um, you have no way to actually do something prophylactically, but um, the First Amendment of the Constitution has various different clauses. And one of them that's just not often thought about is the right to seek redress from the government. This is very important because if your child, now that only really applies to public schools or charter schools, which are for all intents public schools. If the school were to retaliate against the child for having brought a due process complaint, that would constitute a First Amendment constitutional violation, which could be litigated. And the schools are aware of this, and sometimes, and particularly if you have help through that process, they're going to know that Big Brother's watching. And one of the very powerful things about constitutional and statutory violations, there's something called 42 USC 1983, which basically says anybody acting under the color of authority, which means, and it doesn't matter whether it's local, a town, county, state, federal, who violates your statutory and constitutional rights can be held accountable plus pay attorney's fees. That's a sledgehammer, and when used effectively, can really bring the point home. But it's also sometimes, and I use the example from The Godfather 2, when the guy's going to testify and he looks in the back and he sees his brother that they brought him over from Italy, and all of a sudden he has amnesia and can't remember anything. Sometimes you just got to show the weapon and it gets the point across. So, but you still have to wait. Yes, there's always the possibility of retaliation, but you know, when you're dealing with a child, and I say this at the start of every one of my due process hearings, for the adults in the room, this is an intellectual exercise, but we're talking about a child, a student who needs our help. And we can't lose sight of that. It's not about winning. It's not about losing. It's not about right and wrong. It's about getting the best solution for the child. And the earlier you get your child the best solution, the things they need, the more of an effect it's going to have on their overall success, getting through their issues and succeeding in life. And I think that you can't be afraid to take a stand. It's really what I'm getting at here. It's scary, but it's just necessary because your child is depending upon it.
And I want to go back to what you said earlier. You were talking about our due process case where you said the failure point issue was the graduation issue. So the question came in, what is a failure point, and can you provide an example as to how a failure point is implemented?
Well, what that is the exact example. The school's case rises and falls as to whether he graduates this year. If he does not graduate, he's going to get all kinds of services. If he does graduate, he's going to get no services. So, from my perspective, the most important issue I had to work with was, is he going to graduate this year? And, I got the school, all the people at the school to admit he cannot graduate this year. And since he cannot graduate this year, they must continue to provide him services. So that's what I mean by a failure point. It's one discrete decision. It goes one way, he wins. It goes another way, he loses. And I always look to find those failure points in there. Find those failure points in the other side's arguments. That I think is a great example, one of the best I could come up with.
Great. And we do have a couple more questions, but I've kind of given them a glance and they do look like they may be more, special education advocacy type questions, but I'll definitely let you see what your thoughts are and you can give your answer.
I'll try to guide you along, but what I will say is, if there are questions that are not really specifically on topic tonight, my team will see that you get an answer.
Exactly. I mean, I'll go ahead and ask you just because, they're there and I think you may have an insight, or you can, sell our firm a little bit, give a little plug. All right. Can the school force you to change a section of the IEP? The accommodations were cut down to half without documented data. They claim it's accommodations and no data needs to be collected. This is how they're
No,
basing the cut down on accommodations.
no, they can't make changes without data.
So what would you recommend they do if they if the school is standing by that.
I think I would pin them down to give you an exact reason for that. I'll give you the example of the due process hearing I'm in right now. I focused on the projected graduation date was 2026. And it was still that as of January. And then in March, they changed it to 2025, believing that he was going to graduate. The only problem is they never spoke to his residential school to find out that he was failing all of his classes and would not graduate. Nevertheless, um, the school proposed that change but didn't back it up with any data to support that change. And I've been hammering on them over that. And then they sent the draft IEP to mom on March the 9th. And once the mom saw they were going to change the graduation date to 2025, she filed for due process. So I would pin them down to give you an exact explanation as to why they're making the change. And if they don't have the data support it, then that potentially can lead to a due process complaint.
All right. And the second question, my son started an internship through the school, still with an IEP and through the school system. His IEP was not followed and help was not given to him that he needed. He was dismissed 5 weeks before graduation from the program. It was not done properly with an IEP meeting or any meeting to discuss prior to the dismissal. He was not transitioned to home before the dismissal, and the IEP meeting was then set to cover up the mistakes. Then the IEP meeting was set up and done without us after we requested another date. After the IEP meeting, an IEP was not given to us by the EC teacher, and we requested a copy, still no copy from her. It was told it would be mailed, and we still have no copy. How do we proceed with this? The dismissal was done without reason.
That's starting to get more towards probably not due process and probably more towards litigation. I mean, that one's got so much wrapped up in it. I couldn't possibly answer that without a lot more details. But I think that, that may be a great example of a case that goes right to litigation at this point. And it depends on what the status is of your child today. For example, if your child got kicked out of the program, but he's graduated, he's in college, or in some kind of program, that's very different than if he's now prevented from progressing and moving forward.
Right, right. Well, that was the last question we had, and we are nearing the end of our time. So I'll say thank you, everybody, for coming. And thank you so much, Keith, for answering the million questions I threw at you and the questions, of course, from everyone watching. Do you want to give any final last words about us, about our firm, and how we can help?
Sure. So I appreciate all of you spending a little bit of time with us tonight. I know time is very, very precious. But we wanted to try to give all of you a little bit of insight into an area that's scary for a lot of people, but it is manageable. Nevertheless, my firm, we focus on helping kids. That's really at the end, not the intellectual exercise. And so I suggest that if you have some issues, if you have anything that's a concern, you can reach out to my team and we'll take a look and see how we might be able to help you. And it can go in because we have a team that can start everywhere from initial eligibility all the way through due process and beyond. We really have an effective way of taking a look at what's going on and trying to help you get through that and give you some guidance. So, like I said, if you've got a question we didn't answer, feel free to reach out to us. We'll be happy to get them answered for you. And thank you for coming. We're going to try to put these seminars on as regular basis as we can on various different special education topics with various specialists and experts in the field. And we hope to see you at our next session. Thank you.
Thank you, everyone.